kick things off. Again, we've got Brad Gross here. He's going to be talking about everything legal as it
Everything
pertains
legal.
to everything
All things
as it
legal.
pertains to
Traffic tickets,
to yeah,
uh,
parking tickets.
whatever it is. Yeah, all things
There you
legal.
go.
Or we'll just
There you
focus on
go.
MSPs and leave the rest for
Yeah.
being offline. But whatever you want. Mhm.
So, Brad, I'm going to go ahead and let you take over here. You can speak for a little bit, and then we'll
Yeah,
just open it up
sure.
to general questions and go from there.
Sure. So, I think that right now, the biggest legal issue that MSPs are learning about or asking about relate to non compete agreements, which are being banned by the FTC. I mean, other things are going on. We could talk about pain points in contracts and so forth. Let's talk about legal stuff, non-solicits. So we could talk all about agreements and pain points in agreements and what you should be doing. And I'm not diminishing that, but right now, if you were to say, well, what's hot in the area of legal and MSPs and so on, people are asking about non-competes because the FTC issued this final rule in April, and it was just published this month, that effectively bans non-competes for everybody, not just MSPs, but for everybody. And that was really the genesis of. The genesis of that was years of investigation, years of fact finding by the FTC, where they found something like a 30% of hairstylists were subject to a non-compete. Right, 45% of the physicians were. And the interesting thing is that when I talk about this topic with people who are calling me, and some people like non-competes, some don't. I said, okay, here's why you should always look at a non-compete agreement and wonder, is this a good thing? If I were to ask you guys, like I said, 30% of hairstylists were subject to it, 45% of physicians. What percentage in society, in state by state, what percentage of lawyers are subject to an enforceable non-compete, right? Again, 45% of physicians and electricians was like 43%. What percentage of lawyers are subject to that? And the answer is, unless someone wants to just take a wild guess.
100.
Anybody?
100.
Anybody?
Zero.
What's that?
100.
Zero.
Zero.
Norm goes with zero.
Yeah.
And Norm is correct.
Yeah.
There is not one lawyer in this country, unless he sold his law firm, which is a little different, right? I'm talking about just generally an employee of a law firm. 0% of lawyers are subject to non-competes. El Zippo. Why? Because the bar in every state, has ruled that lawyers cannot be subject to a non-compete agreement. Who wrote that? Lawyers. So if lawyers say we can't be held, and they come up, by the way, the logic behind it is they say, well, if you look at an attorney and a client, there's such a tight, attorney-client privilege relationship between them that if the attorney can no longer compete by, going to this customer, if the attorney leaves the firm, who do you hurt? Do you hurt the attorney? No, he'll get to other clients. You hurt the client, right? Because now the client has to go to another attorney, tell him all of his deep, dark secrets, right? So it hurts the client. So we're not bound to non-competes. That was the logic of it. Okay. I think that that's a little bit ridiculous, personally, because lots of people have lots of lawyers. Okay. And it's all, the discomfort of going to a new lawyer. How about the discomfort of going to a new doctor, right? And disclosing your medical history? That we never had a problem enforcing. Don't worry about the doctor-patient confidentiality. You'll find another doctor. But the point is, if lawyers wrote the law and lawyers aren't subject to a non-compete, you got to wonder why everyone else is. So it did not surprise me that the FTC, after years and years, said, we're not going to do this anymore. We are now going to take it off the table. Okay, I'm just going to jump right into it. So non-compete. What the FTC said was that 120 days after the rule was published, and I believe the rule was published either today or yesterday. I know that if you do the math, it's as of September 4th, 2024. Okay. So right now, this rule is not in effect. September 4th, 2024, and all times thereafter, it is. And what the rule says is that you are not allowed to have a term or condition of employment that prohibits a worker, penalizes a worker, or functions to prevent a worker. Think about this: that prohibits, penalizes, or functions to prevent a worker from seeking work in the U.S. after the conclusion of employment, or operating a business in the U.S. after the employment that worker currently has concludes. So, that covers a lot, right? You're not allowed to prohibit a worker. So you can't say you can't compete against us. That gone. Okay. You cannot have something that doesn't say you're not allowed to, but penalizes you, right? If you go work for a competitor, then we are not going to pay you a bonus. Then we are not going to whatever it is. If there's a penalty, that's unenforceable. But the real kicker, and I think that is what's provoking the most thought and discussion, is you're not allowed to now tell your employees, you're not allowed to put a prohibition on them that functions, that has the functional equivalent of a non-compete, right? So what might be the functional equivalent of a non-compete, right? That's the question. Just by way of extreme example, okay? Let's say Jay, you joined last, Jay, so you're my target now. So Jay, let's say, works for me. He doesn't. In case anyone's tuning in, Jay does not work for me. But let's say Jay works for me, and I have him sign something that says, as a condition of employment, okay, here's the deal. When you leave, you are allowed to compete against me. You can do that. However, you are not allowed to solicit any of my customers, okay, both actual and potential. Actual and potential. But you could start your own business and compete against me. Just don't solicit my actual or potential customers, right? Is that a problem? Well, Jay already left because he knows what I'm trying to get at here, which is, well, then who the hell can he work with, right? If I'm an MSP and I advertise nationally, well, then I guess the entire country is. Well, let's say you're an MSP, but you're only in Florida. Okay, but I promote myself through Florida. So now Jay has to move to Texas. I mean, where's he going? He has to move out of the state. That is the functional equivalent of a non-compete. And we can think of edge cases, right? Fringe cases where you say, well, is this the functional equivalent of a non-compete? Is that the FTC, in its 570-page decision, decided not to go there? The FTC said, we are not going to go to the fringe cases. That is going to have to be determined on a case-by-case basis, okay? And yes, I did read it all, Norm. As a matter of fact, literally, I read all 570 pages, outlined them, the whole thing. So the idea is that, it's almost like we know it when we see it now. But the obvious things, you can't compete, you can't, you're going to be penalized if you compete. You can compete, but basically I'm going to make your life so difficult if you do. It's not worth it.
So now, Brad, if you did have a contract that said something like that, you can't solicit any of my customers, actual or potential. Obviously, the potential thing's not going to hold up. Would that invalidate the entire agreement, and now the guy can go after your actual customers?
No. So here's the deal. Your question relates to a non-solicit, okay? Different than a non-compete. And I know that you understand the difference, but just in case somebody hears this afterward on the recording, let me break it down. A non-compete is you work for me flipping hamburgers. A non-compete says you cannot flip hamburgers for anyone else for the next X number of months or years within a certain geographic territory, right? You cannot do what you do for me for someone else within a certain period and geographic scope. Okay. So if I fulfill that, that goal, you can't even put bread on the table, right? Because you're a trained hamburger flipper. What are you going to do? right? You actually have to go into a different industry. Okay. That's
Hot
non-compete. Hot dogs. Maybe you might be right. See, there's always a loophole. That's Jay should work for me because he's thinking like a lawyer. I like that. I like that. God damn, I didn't think of the hot dogs. Damn it. Anyway, so what a non-solicit is different. It says you can go flip burgers for anyone else. You can go next door and flip burgers, but you cannot take my customers and you cannot take my employees, from me. Non-solicit, if they are drafted correctly, are not non-competes. And in fact, the FTC specifically said that it is not banning non-solicitation agreements, provided that they do not create a situation where there's a functional equivalent to a non-compete, right? So in my example to you, Jay, I did a functional non-compete, right? You could compete, but you can't solicit my customers' actual or potential. That's the functional equivalent of a non-compete. But what if I had an agreement that said you could compete against me, but here's the deal. You cannot take my employees in your new business, okay? And you cannot, for a period of 6 months, you cannot solicit customers with whom you worked. Right. You cannot solicit my employees, and you cannot solicit the customers with whom you worked while you worked for me. Okay. That's a non-solicit. So think about that. Now, Jay wants to open up his own MSP practice. He can't steal my people. Right. Is that the functional non-compete? No, there are tons of people he could find. Right. He can't take my customers, the ones that he worked with. Right. That he worked with while me. Well, is that a non-compete? No. That's just a very small subset of the entire world of customers that he could go after. So that a non-solicit would be enforceable in that circumstance.
But it has to be those that he's worked with versus if he's aware of other clients within our organization that maybe other techs are working with.
So the interesting part, okay, is that now we get into non-solicitation law, which has evolved over time. We now know, okay, let's work backwards. We now know that if it's a functional equivalent, okay, a functional equivalent, it's not going to be enforced. A functional equivalent of a non-compete, it's not enforceable. Okay, so how far can we go with non-solicitations? Okay, most states are now evolving to the point where they are saying that a non-solicit could be overbroad and unconscionable if you start saying things like you cannot solicit all of the customers of the company, because the person might not know all the customers of the company, might have had no contact. The customers don't know them. So what is the business strategy? What is the business reason for telling someone they cannot solicit your customers when they never dealt with the customers and the customers have no idea who they are? And the person who you're restricting, he or she might not even know who these people are. What's the business purpose? And the answer is, well, just because we want to, it's what we want as a business. And what courts are saying is that's overbroad. Okay. It used to be, let's go back 10, 15 years ago. You could absolutely pass muster. You can't deal with our customers. Courts would say, yeah, it's non-solicit. But now the way things are evolving, they are really trying to limit non-solicits to the minimum necessary to protect the business interests. Well, what we're seeing in more and more cases is customers with whom you worked or with whom you had contact within a period of time, let's say a year, while you worked here and so forth. But just to say all of our customers, you run the risk of being overbroad. If you're an MSP, if you're an MSP that you have 30 customers, you could probably get away with it. If you're IBM, right, you probably can't.
What if you say, clients that you had access to, because unless you've locked down your PSA to only give access to clients that they specifically work with, they essentially have access to all clients in your database.
If you could show a good business reason for that, and that would seem reasonable to do, again, it's sort of these fringe cases where you'd say, well, what about this? then you're just going to get into what does an arbitrator or a court think is reasonably tailored to protect the business interests. And your question, Norm, about have I been in court to do this? The answer is yes and no. I have not had the occasion in a state or federal ancillary matter to argue this specific argument, but I have kept people out of court, okay, by pointing out the weaknesses of their non-solicitation and saying, if you pursue this, okay, we're going to not only beat you, but under the terms of the contract, we're going to get our attorney's fees and so forth. So that has made many a company back away. But I can't say that I actually stood up and made this argument in a state or federal court. The idea, by the way, is to keep people out of court, right? By interpreting things correctly. So I'd like to think that's what we do. Yeah.
So no, absolutely zero when it comes to, potential customers, because that could mean the world.
Or at least a large enough subset that you have effectively created a non-competition. And by the way, you say, well, my customers are in Florida, so move. It's probably not going to be valid to say he could move to Georgia. Okay, so I have to uproot my entire family. It might be valid to say our customers are in Miami. I'm just using it because this is where I am. Okay, you have to go to Fort Lauderdale. That's not a major deal, right? That's an extra 10, 15 minutes. But state by state, that might be overbroad. Yeah.
So even, because I mean, alternatively, any clients that you may be engaged with in the sales process, I mean, because you're not going to want to name them, obviously, in an agreement,
Right.
Right. So, interesting. Yeah.
Mm-hmm.
I mean, I many, many years ago, even with what he suggested, that non-competes aren't really what they're cracked up to be, even at that time,
Agreed.
and
Agreed.
so
and I've been saying this for years, by the way. For years, I've been saying to MSA.
Still had it.
Yeah. I've been saying to MSPs for years that they don't want non-competes, they want non-solicits. Okay. The question you asked, Jay, you also asked a question about is an agreement that has a provision like this in it now no good, or is it, void? The answer is no. The FTC actually specifically said that this does not void an overall agreement that has an unenforceable non-compete in it. All we're doing is we are saying that portion of your agreement can no longer be enforced. So you still have an agreement if you have NDAs, non-solicit, whatever it might be, that's all enforceable. But that one provision, just take a little like a little how they cut out drywall or something, a little knife, right? Just cut it out, pull that out, and that's what you have there. The other issue is that there is one exception to this rule. It is a very small exception, but it is an exception. You say, well, what happens if we have an executive, right? An executive person who's under a non-compete. Now what? What happened? Oh, two exceptions: executive people under non-competes and sale of a business. So first, as far as executives, moving forward, you will not be able to bind an executive to a non-compete after September 4th. Before September 4th, executives, what they call senior executives, can be held to their non-compete. Okay. However, who is a senior executive? That's the question. Moving backwards, looking back, okay, who is a senior executive? A senior executive, according to the FTC, is somebody who makes $151,164. I am not making that number up. You say, what the WTF, right? What is function Wednesday? What the function? Where'd you get that number? It's in like page 300 something. They do a whole analysis of what they think executives in the US make. And they've come up with the idea that if you're making $151,164 or more, you are now in the potential class of a senior executive. But there's a second test, okay? A second test. It's not just the amount of money you're making. You also have to hold a policy making position. And this is where most people who think they're executives falter. Because a lot of executives, let's be candid, if you're an executive in a company, you're probably making $151,000 or more. Okay, I get it. But if but holding a policy position, that's something entirely different. This is where you see all the companies in the industry, all the vendors, you call them up, and I'm a VP of marketing. I'm the senior VP of community, this and that outreach, right? I'm the VP. Everybody's a VP, right?
Every bank branch manager is a VP.
Every bank manager is a VP. It's funny.
Right.
I like to think of it because of my prior law enforcement background. I was a prosecutor. Every agent, every person in the FBI is a special agent. There is no agent. There's no agent Joe Schmo in the FBI. Every person in the FBI is special agent. What makes them a special agent? I don't know, other than that's what they're called. The point is, if you're looking at these vendors, right? I'm a VP of this, that. Doesn't that make them a senior exec? What if they're a VP of market outreach and they're making 175 grand a year, right? Aren't they bound to it? No, because they have to also hold a policy making position, and the title of the position means nothing. Yes, it could be instructive, right? About if somebody's a CFO, they probably do hold a policy making decision, but you have to actually look at the job. And a policy making decision, according to the FTC, is a person who routinely makes decisions and has final authority to make decisions that control significant aspects of a business. Routinely makes decisions and has final authority to make decisions that control significant aspects of a business. So if you're going to say, well, I'm the VP of communities and I do make decisions, well, let's look at your entire organization, not your division, your organization. Do you have the authority to make significant policy making decisions that will significantly impact the entire organization as a whole? Now you start seeing where, VP of this and that and so on, they don't have that kind of power, right? They have to report to somebody else who reports to the board, they can't. So what the FTC is basically, most of the people that that call themselves senior this and that, they're not senior VPs and the senior executives. Instead, you see all these people with all these titles, and you think, well, if I want to go after that person, I want that person to work for me. Again, you're going to talk to counsel and make an evaluation, but I'm telling you now that most VPs in the industry are not going to be senior executives. They're just not.
So I want to throw a couple things out. A couple things that occurred at that time, both my attorney at the time and my business advisor, my business mentor. We were looking at $15,000, $20,000 if I wanted to take him to court, and the attorney and my business mentor talked me out of it and said it's not worth spending that kind of money to try to go after him. So I just tabled it. One of the things that my business mentor said is, ultimately at the end of the day, you got to think about the service that you provide as an organization versus an individual. And so one of the things that really we worked hard at, and we still do, is don't let any single individual, any single employee have so much of a relationship with any of your clients that they feel like they're doing business with that employee. Make sure that they see, it's in the entire organization, that everybody that's involved, because then they will look at it that if an employee leaves and starts knocking on their door, they're going to be like, well, I'm not going to walk away from Dan's team. Dan's team is what makes, Greenlight what it is versus Joe Blow, right? If you let any individual employee have so much power and take such a strong lead in the relationship, that's only going to allow that client to maybe consider making a change.
Well, what you're describing, okay, is a strategy that a company can use post the FTC rule, right? Again, it goes into effect September 4th, assuming that no court challenges it, right? No court says suspends it or delays it, assuming, and there are 3 or 4 lawsuits that have been filed trying to overturn it or at least delay it. So far, it has not been delayed. It has not been derailed, but we don't know, right? There's a lot of time between now and September 4th. But assume for a moment it goes into effect. The question is, well, now what do companies do, right? How do we protect our stuff? You just identified a very, very good way, which is you don't need a non-compete to have good business sense to know that you're not going to put all of your customers' eggs in one salesman's basket, right? I've always found it curious when MSPs rather had employees that allowed their customers to contact their salespeople and their people on their personal cell phones.
Big problem.
It's like, right. So this person leaves. Now that's a personal cell phone. You say, well, that's our phone. No, it isn't. This was my personal number. I had it before I worked for you. Well, we want the number. No, you're not getting the number. So now all these customers are calling this guy or this woman after he or she left. That's crazy. Your strategy is a good one, right? Maintain control, make sure they understand they're a customer of the company, not a customer of the individual.
The way we position this to the technicians is last thing you want to do is get a call from a client, at 7:00 at night saying, hey, I need help. And whether it's a company provided phone or your own personal phone, we want to train all clients that they route the calls through our primary number. And that's the only way that they should be contacting us.
Agreed.
And I think it comes down to policy and procedure. And
right. And other agreements. You could still have a non-solicitation. You could still have a non-disclosure. You could still protect your stuff if it's a trade secret using trade secret law. As the FTC pointed out, and I agree with them. I'll tell you, I agreed with the FTC position. I always thought non-competes were ridiculous. They said, look, for those of you out there who think that this will spell the end of your business and this is going to be a disaster and lead to, end of days, they said, we could look at the states that for decades or more have prohibited non-competes. And they point to California, right, as one. 4 out of the top 10 tech companies are in California, right? And a lot of smaller, obviously, tech, Silicon Valley and all, they aren't allowed to enforce non-competes, and they have never been allowed to. I mean, never. Since any of us have been alive on this call, they've never been allowed to do it. And yet they seem to be doing okay. Right? They seem to be doing I think tech companies are doing okay out in California. And that's their point. The point is, of course, you can still run a business and so on. Don't tell me the world is ending. It's not. All that we're doing is getting rid of what we have found to be a coercive and
unenforceable,
a coercive, exploitive way of doing things. We were just saying that's not the way things are going to be done now.
What was the catalyst for the FTC to make this judgment? Was there some kind of pending litigation or something that spurred this on? Or
no, it was just one of those. The idea behind the FTC is their sole mission is to prevent unfair and deceptive trade practices, as well as practices that may harm commerce overall. So, when you're thinking about the types of issues that could be unfair, there's probably not a better one than non-compete. Whether you agree with it or not, the question of are they unfair, these provisions or not, that's a fairly reasonable question that people can debate. So they took it on. They started looking into this, I think, back in 2018 or 19. I mean, 5-6 years ago, and they collected comments from the public. And as they point out in their final rule, they talk about the whole background of it. They received 26,000 comments. 26,000 comments from the public, 25,000 of which opposed non-competes. Only 1,000, right, said, yeah, we think it's a good idea. And probably those are from people who have, businesses that have them. 26 that, and, the decision, their rationale is in the rule itself, and it is replete with people saying, I was a doctor and now I can't help patients in this area. I was a hairstylist. Really? I mean, all kinds. I was an electrician, I was a plumber, and what they found was that it's, yeah, while it helps the business that is trying to enforce it, it not only hurts the person who's subject to it, it hurts the community at large, right? Because if you could prevent good people from moving on, you're preventing innovation, right? You're inhibiting competition. Because good people can move to different places and expand their skill set and expand the skill set of others. They just found it to be harmful, so they said enough's enough. Yeah. The interesting part, by the way, one other thing I wanted to mention, because again, going back to Jay's question about does it nullify an existing agreement, it does not nullify an existing agreement. However, and this is the real fun part, the FTC said if you have a non-compete provision with a worker or executive that can't be held to it, okay, you actually have to deliver notice to that person. There's a mandatory notice requirement that says you have to either write to that person, email that person, or it could be done by text message, by the way, as long as it is to that person directly. And they give a sample of the notice. In fact, I could probably pull it up. This is actually from the FTC. Okay. And if you read it, it's really telling the employers that not only do you have to tell employees that they can compete, you're almost encouraging them to, right? And this was the sample that they give. As of date of employer chooses, but no later than the effective date, which right now is September 4th, right? Employer name. So let's say it's Brad MSP, right? Brad MSP will not enforce any non-compete against you. This means as of September 4th. And read these bullet points. You may seek another job with any person, right? You may run your own business, even if it competes with us. You may compete with us, right? With Brad Gross MSP, following your employment. You have to give this notice to all people who were under a non-compete. So that's fun.
You give that? What?
Yep, that is a mandatory requirement. Now, the notice that you see on my screen is the suggested language from the FTC, but their suggestive language follows the rule, which basically says you must tell them that your employer, that the specific person can compete against you, and that they can seek employment with any person that competes with you. They suggest this language. You could use your own language, but understand it has to be specific, and this is the minimum that they say should be used. So if you don't give the notice, okay, then you are not following the FTC rule. Now, I'm going to give a disclaimer, and then we'll talk reality. Okay. Disclaimer. You should always follow the rule. The rule says that you have to give notice. And if you don't give notice, that the FTC can hold you accountable for that. Okay. Let's talk reality. Can an employee sue you because you didn't give notice? Right? There are all these bottom feeders. I'm going to edit it for content here. Bottom feeder plaintiff attorneys, right? Who are just waiting to sue employees. Oh, you didn't serve a mandatory notice, class action. Can they do that?
Better call Saul.
Better call Saul. Exactly. The answer is no, they cannot. No, they cannot, because the FTC promulgated this rule under the FTC Act, which is a federal act that is only enforceable by the FTC. Okay. So anything that comes from it is only enforceable by the FTC. So if you do not comply with this rule, the only person who can come after you is the FTC. Will the FTC come after Brad Gross MSP, a 5-man MSP in, Arkansas? Realistically, probably not. Okay. But again, you won't be able to enforce this. And if you say, well, what if I enforce it anyway? right? Well, the employer can probably take you to court, overturn it, and a judge might look and say, you knew better. I'm going to hit you with punitive damages because you knew better. So I would not try to enforce the FTC. I'm sorry. I would not try to avoid the rule if you're an employer. I wouldn't try to enforce it, a non-compete when you can't. The mandatory notice part, again, disclaimer, you should follow the law.
If they are currently under a non-compete, or does this have to be delivered to every single employee in America?
It's only if they were under a non-compete provision that
Okay.
otherwise would be enforced today.
So what
In
about
other
the
words,
difference
if you and I had a
between-
non-compete and it expired 6 months ago, I don't have to send you a notice. But if you and I have a non-compete and as of September 4th, this goes into effect, I got to send you a notice, my friend.
What about scenarios, because my mindset on this is more so upon termination that, non-compete, non-solicitation would be into effect. What
Yeah.
about while they are working for us?
Mhm.
So is this mean that
Good
while
question.
they are working for us, they could compete with us?
Great question. So the non-compete, the law specifically says, and the FTC actually touched on this also, after employment ends. After employment ends. So your question is, what if they're working for me and competing? Oh, no, no, no. You could stop that. That is a non-compete. This is after employment ends. Well, how about moonlighting? How about not while I'm working from but I work for you, Dan, during the day, and I go work for Josh at night. And maybe there's some competition there. You can prevent me from doing that because, again, the rule applies to after employment ends, and moonlighting is not covered.
Okay.
Mm-hmm.
Unsolicited would cover an employee doing side work for one of your clients after hours or something, right?
Yeah, I'm not even talking about your own clients.
Not just the non-solicit. You could actually say you can't compete with us as long as you work for us. As long as you are, the rule specifically says, okay. In fact, I could even show you a slide on this. There's your non-compete clause. Okay. And I circled there the sections of the statute that you need to think about. Okay. Functions to compete, seeking employee, right? But look, to answer your question, where such work would begin after the conclusion of the employment. Even the other part, operating a business, you're not allowed to stop someone from operating a business after the conclusion of the employment. So while they're working for you, you could have a non-compete. While they're working for you, you could stop moonlighting, right? You could do all of that. You could actually have a non-compete. But the moment that person says, I'm out, it disappears. Gone.
All right, everybody. We're at the top of the hour. I want to be respectful of everybody's time. Brad, as always, appreciate the chat. Love your knowledge and your dedication to the channel.
So, and if anyone needs to reach me, hit me up on LinkedIn. I'm easy to find. So feel free to reach out.
There you go. All right, everybody. Have a awesome rest of your day, and we will talk to you guys soon. Peace out, everyone. Thank you, Brad.
All right, guys. Take care.